Good morning, good afternoon, and good evening to you all. Welcome to today's webinar, Pandemic Aftermath Shield Your IP in the Digital Era. I'm your session moderator, I'm Arpita Dutta. Also, I'm the Mackrell International Intellectual Property Group Practice Chair and a Senior Legal Consultant at Lewis International Patent Office and Lewis & Charles Attorneys at Law. This is one of the most reputed and oldest IP and full service law firm in Taiwan. So it is really my great pleasure to welcome you all to today's webinar. Why we chose the Pandemic Aftermath Shield Your IP is because we have seen that since the pandemic started, companies around the world went online. They promote remote working, online data sharing, online transaction, e-commerce. So we can confidently say that our clients or companies around the world has no more boundary. There is no limitation. If there is limitation, only two most important issues is bothering them. One is their security, and the second thing is business entity, unfair competition, and the infringement. To avoid these two issues, there is only one answer to that, is intellectual property. Whether it is registered or unregistered, intellectual property can only help companies to gain the most benefit, most advanced. And big companies around the world, they have already understand that issue. And they start ensuring they are all intellectual property more in the patent form or other ways. And we have seen during this COVID-19 pandemic, where the companies around the world is starving how to handle their business, but those big companies are using more patent, and the PCT application has increased more than 5% last year. So this is one of the advantage for the big company. But what about the small and medium-sized company? Because they are now trying to fit into this new environment. So in order to reduce their problem, and we Mackrell International team trying to find out how to help them. And because Mackrell is a dot where all over the world is connected to, and we are having more than 170 offices from 100 firms and around 65 countries. So we give you a detail about how this IP can help on the online platform, and also what are the legal changes are coming on to help you during this pandemic. So Mackrell International Family is one of the biggest network for the individual practicing law firms, and it helps us to access to the new markets together, and it's a perfect, powerful connection. Beyond our clients, also we have another one advantage is to educate each other, educate our clients also. So that's the most beauty of the Mackrell International. And today with me, I have three experienced IP attorneys. You can see Anita Gerewal. She is the partner at Caroline Sha Syah from Malaysia. Next is Brody-Brown. She is the counsel at Hoge Fenton from Silicon Valley. And next is our third speaker is Patrick Bear. He is from Deckelman from Germany. And I think they will give their own some of the introduction, but I would like to give a very small information about them. Like Anita is a very highly experienced, and she is taking care of the IP and corporate issues for several years, more than 10 years. And we are really very happy to have her with us today. And the next is Jana. I don't want to talk about much about her. She just only one introduction for her today I would like to give her. Her colleagues call her the trademark guru. So you can know about the depth of her knowledge about the trademark. Not only trademark, she is also very qualified for the all intellectual property matters. And Patrick, I don't want to say much. I think you can see her presentation, and I can assure you that you will have a real good takeout from today's whole seminar. So At the end of our session, we have a question answer part, so that if you have any question during the session, please feel free to reach out to us. We will answer to you. And in between, please help us to mute your speaker so that there will be no unnecessary noises. And at the end of the session also, you can find all of our information. If during or after the session, if you have any question, please feel free to reach out, and also you can reach out to the headquarters at your convenience. So I would like to welcome Anita for starting the session. Anita, the virtual platform is yours.
Thank you, Arpita. Thank you for the introduction. Hi, everyone. I'm Anita Gerewal from RAM, Caroline Sha Syah, Kuala Lumpur, Malaysia. As Arpita has aptly introduced the topic for today, which is very relevant and very important to what's happening around the pandemic and the fact that IP is core to the changes that are happening around. As we all know, there is increased digital activity, remote environments, and entirely new ways of collaborating that has come about after the pandemic. And these new ideas will keep on coming in as we move on to 2022. Some may leave a permanent impact, and some may be temporary and discontinued. So I'm very quickly going to look at the trends that we are seeing, the challenges, and how do we look ahead beyond this pandemic. So that's the gist of what I'm going to present today. So the first thing that we want to look at is the growth in e-commerce during the pandemic. What has happened, the trends that we are seeing. When the pandemic happened, many businesses had very quickly pivoted to online business simply because they did not have a choice. So most of the physical businesses either closed or quickly went onto the online platform. And of course, the ones who were already there had a better head start. What we have to understand is that it wasn't enough. They also realized that it wasn't enough to have just dedicated websites for their brand, because they can't just simply have websites and wait for shoppers or customers or clients to come to them. And this was because almost everybody went online, so there was saturation and competition. There was a need to be present elsewhere, to go look for these customers, to grab opportunities. And that's how we have seen a horizontal growth, rather than just having a dedicated websites for your brands, as we have seen pre-pandemic, the kind of e-commerce presence that we have always envisioned for brands. So online marketplaces have come about. Now, Amazon and Alibaba were there before the pandemic, but a lot more marketplaces have been born after the pandemic started. And there are a lot of local marketplaces that has come about as well. For example, in Malaysia, we have Shopee and Lazada, and likewise, there would be similar ones in other countries. And not only that, there are also a lot of sales, a lot of activity going on social media. Before this, we look at social media as something that to just socialize. We go on Facebook or Instagram to add friends and keep in touch with them. But things have changed. It has now become a marketplace. That's where now we go to buy things. That's where we go now to look for things. So now we have social medias like Facebook and Instagram have introduced many tools like live sessions, which allows users to sell online and sort of give a virtual shopping experience to the users. So they can pretty much show their like fashion goods and sell online. Then of course you can set up shops on Instagram and Facebook to make sales. So you don't even need to have dedicated websites. You don't need to have a website where you can make sales, you can do it over the internet. There are sponsored ads, there are a lot more tools that these social medias are now adapting very quickly to what's happening with the activity that's happening around. Now, with influx of the brand owners going online, there's also influx of new users. Users meaning people who are looking for these things, people who are buying, including senior citizens. Again, because of lockdowns and movement restrictions, they have to now go on the internet to look for things to buy. So we are seeing a lot more activity, a lot more people going online. So with that comes saturation, competition, cybersecurity issues, IP issues, and a lot of other things. And of course, there are new virtual ways of shopping. It's not only restricted to live sessions on Facebook or Instagram. We are seeing use of virtual reality, augmented reality, artificial intelligence, chatbots, e-wallets, all the works incorporated to give a better experience to shoppers so that they can feel shopping in the real, just like the real world. And a lot of luxury brands are doing this because it takes a lot more to convince people to buy expensive stuff online. So that's one way of winning the customers. Of course, the brands like IKEA already had virtual shopping before the pandemic. So again, they had a better head start. But now it's going beyond that. More brands are doing it. It's being used in factories to monitor. Managers are monitoring factory outputs and production lines through augmented reality. So a lot of that is happening. Then, of course, there's content sharing. A lot more content is being shared, whether it's through Zoom meetings, online education. A lot more data and content is being put on the internet. I believe Patrick will be covering a lot more on that, so I will leave that topic for him to explore. There's also geographic shift in supply chains. Now, we all know that China was known as the factory of the world before the pandemic, and people still believe they are. But what had happened with the pandemic is China was one of the first countries to get hit by COVID, and they had a lockdown. They were the first country to be under lockdown. And that's when some issues happened with the product lines, and people had to, there was a slowdown in supply of goods from China. And slowly we have seen trends where there has been some activity in Vietnam and Bangladesh, other countries where counterfeits are slowly starting to come from different places. Now, this information is very important for brand owners to know that there is a shift in supply chain. So information that they've known before this may not be relevant anymore because there are changes happening in the world. And likewise, there's shift in markets and consumer spending patterns. So of course, we see that people are not spending on tourism and fashion anymore, but instead they are spending on self-care items, food. So the spending patterns of consumers are changing, trade channels are changing. So again, these are things that brand owners have to keep up with. So these are some of the challenges that we are seeing. Of course, that's a lot more, but these are some of the important ones. Now, being 1 year, the fact that 1 year has passed, and from the legal perspective, we are seeing these implications now, or seeing the kind of disputes that are coming to us and the trends in the disputes. And of course, with increased online activity, there's increased online infringement, obviously. But what we see is not the typical sale of counterfeit goods or grey market goods, but more novel type of infringements and competition. For example, genuine items being sold by unauthorized distributors, genuine items being sold with use of copyrighted material without consent, price drop, price hike by unauthorized distributors, and therefore there's no control of price by the brand owners. They're losing control over it. So we are seeing a lot more of those kind of activities happening as well, apart from counterfeits and the typical type of infringements. Then obviously there is copying of business methods and ideas, and that's probably because things are changing so fast. There is need, there's competition and saturation, and so there is need for people to move fast, to adapt and to change their business, and sometimes they look for shortcuts. So instead of coming up with something new, creating or innovating, they emulate their competitors or they copy their competitors without thinking of the repercussions, whether they are infringing someone else's IP. And that's again, of course, due to lack of awareness. And it's almost like they're desperate to do it. So we are seeing a lot more of that. And we as lawyers have to ask our clients to do better and stringent clearance searches, because there's a lot more competition and a lot of new businesses or new ideas have come in. And it's almost like if you have thought of that idea, I'm pretty sure someone else have thought of the same idea. Because that's how everybody is, rushing towards or trying to keep up pace with things. There is also slowdown of IP office processes. Now, this is not the case in all countries. In some countries, most of the IP offices have gone online. That was the case in Malaysia. So they were equipped, they had the setup, but most likely they were not prepared for something like the pandemic, the COVID pandemic to happen. So most of the business is being done remotely, but there is a major slowdown in the processes, processing new applications. Although the applications are coming in, there is a huge backlog. So this is again one of the implications or things that we are seeing from a legal perspective. And although disputes have increased, the court filings have increased, and this is again naturally because there's a slowdown of business, and there's budget issues. So brand owners are being more careful or hesitant when it comes to taking the matter to court. So that's some of the trends or challenges or implications that we have seen so far in practice when it comes to IP. Now, so where is this heading to? Sorry. So where is this really heading to, or what are the things that brand owners have to be aware of? Firstly is improving IP protection systems and laws, and there are many players to this. Firstly, IP owners have to be very quick with R&D. So if they've come up with ideas or they have new inventions, they have to develop the idea very quickly and move very quickly, because like I said, if you have come up with something, it is quite likely someone else has come up with the same thing. So clearance searches, moving quickly, these are all the things that the IP owners have to be very careful of with what's happening around. And of course, the platforms that I was talking about, marketplaces, that it's important for the social media and these marketplaces to develop policies that are in line with what's happening and to have better dispute resolution systems. I'm not sure if you know, but Alibaba and most of these marketplaces do have such systems in place, and they're pretty good and pretty fast, where you don't even need lawyers or agents to act for you. Brand owners can directly lodge complaints online and take down pages or any page that has counterfeit products, or if there's any dispute. So these things are very important because of the fast pace of things. Then of course, regulators play an instrumental role. Coming up with policies, updating laws to meet the challenges, to address the challenges that we are facing. And particularly IP offices need to move faster and process this IP, because it's almost, if the IP office is not processing these new applications, then it's almost redundant it doesn't support creativity and innovation. So it's very important for IP office to sort of clear the backlog and move faster. And IP owners have to become more vigilant. So it's no more monitoring or looking for physical stores. It has now all gone online, but there are more places, like I said, horizontal growth. So there are more places to look for, more activity happening, which means that IP owners have to be more vigilant and they have to act fast, whether it's sending, whether it's takedown notices, sending warning letters, or reporting to the authorities. Whatever it is, action has to be taken very quickly for these things. The other thing is it's very important for brand owners to identify what are the challenges that they are facing in their industry and for their business, and to identify what are the potential risks, taking into account these challenges and how they can mitigate this. Now, a very good example would be non-use of trademark. We all know that, that there is a provision in most countries. You have a provision for non-use where a trademark is not used for a certain number of years, and therefore it can be removed from the register. So of course there are businesses that has halted use during the pandemic due to business closure or business decisions to halt for the time being. Now, non-use, the pandemic would qualify as a special circumstance for non-use. But what business owners have to look beyond that is that after the pandemic, we are probably going to face recession. And so it doesn't mean if the pandemic is over, you will be able to resume your business or go back to where you were and continue using your mark. There may be still a lag or a sort of a further halt in the use. So recession then does not qualify special circumstances for non-use in some countries. So these are things that are important. You have to look beyond what is there, and then to mitigate the risk that's there. So of course, preventing the loss of potential IP assets and rights, it's very important for you to do audit and review of your current IP portfolio and licenses to see if you have a shift in your services, you have come up with new lines, new production lines, you have changed things in your business. Does your business cover the new use cover, is covered by the IP that you have? Again, a simple example would be trademark. If you have registered for physical goods or services, it's not applicable to your online business right now. So all these are very important, where you have to look, sort of audit and check your IP portfolio to make sure that all these changes that's happening, it's protecting your IP is still protected, which is more important. So yes, so that's about what I would like to cover today. So if you have any questions, as Arpita said, we'll be taking on questions at the later part. So I will stop here and hand over the session to Dana. Thank you.
Thank you, Anita. Good morning, good afternoon, good evening. My name is Dana Brody-Brown, and I'm with the Hoge Fenton law firm. We're based in Silicon Valley in California. As Anita was discussing, because of the changes during the pandemic, it's more important than ever for trademark offices to update their procedures so that they can continue processing the influx of applications. And the US has just recently passed a new significant piece of legislation related to trademarks. It's called the Trademark Modernization Act of 2020. And our major legislation in the US on trademarks is called the Lanham Act. It's been around since the 1940s. And there have been several updates to it, but not a significant one since the 1980s. So it's about time we do a little modernization. This act was signed into law late last year, and it is to be implemented by the end of this year. The purpose of the Modernization Act is to improve the integrity of the register. There has been an enormous influx of applications, both from the U.S. From U.S. applicants and from overseas applicants. The PTO tells us that there are many registrations where there may be insufficient use. So use plays a very central role in the U.S. trademark system, as it does in most countries, but it is a bit different in that most applicants, unless they are relying on a foreign registration as a basis for their filing, have to prove use during the course of the application process. Most applicants have to prove use before registration. However, many are able to rely on a foreign registration, as I said, and don't have to prove use during the process. And the PTO is finding that there are many registrations on the register where there has not been sufficient use of the mark in commerce in the US. So the Act is designed to address that. It also addresses a circuit split in US circuit courts regarding the standard for injunctive relief when a plaintiff seeks injunctive relief in a trademark infringement case. Okay, so one of the most significant changes of the Act is that it allows for 2 new ex parte cancellation procedures. So under the US current process, any cancellation must be done through the Trademark Trial and Appeal Board, which involves a very significant undertaking that is like a mini litigation. So for a third party to seek cancellation of a registration in the US currently, they might expect to pay certainly tens, if not hundreds of thousands of dollars. And the process might run, a year or 2 or more. So these 2 new procedures are designed to make it easier for third parties to challenge registrations where there has been insufficient use. So the first is called an expungement procedure. And in this case, the third party is alleging that the registrant has never used the trademark in commerce in the US, either as a whole or with certain of the goods or services that are claimed. This procedure has to be brought between 3 and 10 years after the registration date. The second of these new procedures is known as re-examination. It's very similar, but in this case, rather than saying the mark was never in use with certain goods or services, the third party must say that the mark was not in use as of a particular date when the registrant has alleged use. So in this case, the third party is challenging a particular allegation of use that the registrant has made, or is challenging a specimen of use that may have been submitted. So it's slightly different than the first. In this case, this procedure must be brought within the first 5 years after registration. So both of these procedures are designed to be expedited procedures. I mentioned earlier about how long a typical cancellation takes in the US and how expensive it can be. These are specifically designed to be much easier for third parties to bring. So I'll let you, read about what the procedure is like, but essentially a third party files a petition with the office. The director of the PTO reviews it to see if they've met a prima facie case, if they've laid out the basic facts for review. And if so, they will grant the petition, and they will start the proceeding, and then it will be up to the registrant to prove that their mark is in use with all of the goods and services claimed, or to prove that a particular allegation of use they've made or statement of specimen of use rather that they've provided is in fact accurate. We haven't seen yet how this works. These procedures have not yet started happening, but the idea is to make it much easier, faster, less expensive for third parties to challenge registrations where there may not be adequate use in commerce with all the goods and services claimed. In addition, there is a new ground for cancellation at the Trademark Trial and Appeal Board. So this is the entity that reviews the traditional cancellation actions that I mentioned that are more like mini litigations. This new ground is very similar to the expungement procedure that I mentioned. The reason why you might bring it as a regular cancellation, you might bring it if you're outside of the time frame for an expungement procedure, or if you have other issues that you're raising for cancellation in addition to just use. There are a couple of notable changes to trademark prosecution in the US as a result of this act as well. The first is that there will now be flexible response periods for office actions. And by flexible, I mean the examiner will have flexibility to set a different response date. Under current US law, every office action has a 6-month response deadline. So you have 6 months to respond, and it doesn't matter whether it's a substantive refusal or merely an administrative issue. In this case, now the PTO will be allowing examiners to set shorter deadlines if they wish. So they might set a 2-month deadline or a 3-month deadline, particularly when the issues raised are administrative in nature, and a quick response is very possible. I think they will be encouraged to do that. However, the applicants will be able to request extensions up until the full traditional 6-month period. So there will probably be a fee associated with those extensions. But the idea here, I think, is to, allow applications to progress more quickly through the examination process. The other change to prosecution that is formalized through the Trademark Modernization Act is that letters of protest, which have been in use on an informal basis for a long time, are now going to be formalized. So a letter of protest is when a third party sends a letter objecting to registration of an application. This is during the examination process, not during the publication and opposition period. So, as I mentioned, this has been done for, at least 20 years, but the new act formalizes this process. So, there will be a fee for filing a letter of protest. There will be a particular format to file it in, and there will be a particular process that the office has to follow in order to review these letters of protest. They will have 2 months to act on submissions. So this is an opportunity for third parties to object to applications in process without going through, without having to wait until it's published for opposition and go through a full-blown opposition process. So you may be able to protest based on, your own earlier rights in a confusingly similar mark, or based on descriptiveness or other issues. As I mentioned, there's also been a split in the circuit courts. The issue is whether irreparable harm could be presumed in a case, in a trademark litigation case where the plaintiff is seeking an injunction. Some courts said it could be presumed, and some courts said that the plaintiff would have to be subjected to a 4-factor test. This act establishes a uniform rule that when a trademark owner seeks injunctive relief, they are entitled to a rebuttable presumption of irreparable harm. So this also eases the burden on trademark owners a bit in that they don't need to submit a lot of evidence to show harm to their brand in order to obtain injunctive relief. And in fact, the burden shifts to the defendant to rebut that presumption. So just to summarize, the Act allows for the 2 new expedited cancellation procedures that we discussed, the expungement and the re-exam. It allows for the 1 new ground for cancellation that is similar to expungement. It allows for the 2 changes to prosecution, the flexible office action response dates, and formalizing the letters of protest. And the new uniform rule that there is a presumption of irreparable harm in trademark infringement cases where the plaintiff is seeking an injunction. I think all of these changes are designed to encourage third parties to help police the register, to help clear away registrations where there is no use in commerce in the US. Especially those where perhaps there has been a fraudulent filing, fraudulent specimen, and also are designed to help speed the process of review examination in the US. So I think they're all positive changes, and time will tell if the procedures work. In terms of really encouraging third parties to actively assist the trademark office in policing the register. But I think it's a good step to make it less onerous for brand owners to police their brands and encourage them to do so. Thank you very much. I am now going to turn it over to my colleague, Patrick Baer.
Thank you, Dana. Thank you for your insights in these new developments in US trademark law and for handing over the session. My name is Patrick. I'm a lawyer with Mackrell International member firm Dankelmann & Kerst from Frankfurt, Germany. And in these next few minutes, I would like to talk about trade secrets in a digital world, another aspect of managing and protecting your IP, and how the pandemic has impacted the need to better protect these trade secrets. So starting with at the beginning, what actually is a trade secret? As you may know, it is usually very difficult to pinpoint the specific legal terms in intellectual property law because they mostly refer to intangible assets like information, know-how, creativity, or knowledge in general. And therefore, we also have this problem with trade secrets, in this scenario. So the World Intellectual Property Organization qualifies any information as a trade secret if it is commercially valuable because of its secretive nature, if it is only known to a limited group of persons, and is subject to reasonable steps that have been taken by the rightful holder to keep these information secret. That can be confidentiality agreements, NDAs, or also employment contracts with relevant clauses to that. So basically any information can be a trade secret if it has value for a company and is not publicly known. And those trade secret as a legal term then refer to an IP right, an intellectual property asset on confidential information which require no procedural formalities for the protection. So there is no register as we may have, as we may know from trademarks or patents. And due to that lack of procedural formalities, trade secret can be protected for an unlimited period of time as long as they remain a secret. And they can also be licensed or sold as any other IP right. So the next point I want to shortly come to is, why do I need to protect trade secrets? I mean, it is obvious that any information that gives a competitive advantage to your company or to companies because it is only known to one company should not be disclosed. But to put that into a bit more of a perspective, I would point out a survey conducted by German digital association Bitkom, and they found out that damages caused by corporate espionage, cyber attacks, and the resulting disclosure of trade secrets and confidential information has exceeded the damage threshold of 100 billion euros for Germany alone in the year 2019. And almost 73 billion euros of these damages are directly linked to follow-up IP infringements like patent infringements, plagiarism, knockoff products, or simply the loss of competitive advantages. So there is a need to protect these non-registered intellectual property rights and to prevent the risk of disclosure. And this risk of disclosure can be, in a general way, described in two ways. External and internal factors, where the external factors are mostly unlawful actions by third parties like cyber attacks or corporate espionage, targeted extractions, or the ill-intended use by employees, not necessarily whistleblowing or reverse engineering, although these are also ways of how trade secrets can be disclosed. They are, for example, in Germany, under the Trade Secret Protection Act, not covered as unlawful actions, but these are external factors that can lead to the disclosure. And then there's, on the other hand, internal factors that can lead to disclosure, which is negligence by the holder. And the point I want to focus on today is not accounting for new technologies and carelessness. And due to the increased use of online technologies in the pandemic and in the pandemic aftermath, there has been a significant effect on these internal factors and the carelessness. So how did the pandemic affect these internal factors for risking disclosure? Due to the pandemic, we all have noticed, and Anita has pointed it out in her session as well, that the use of online tools, online meeting tools, has increased significantly. We, for example, have taken part in a number of digital virtual court hearings. All our meetings with our client have transferred to digital hearings. We are now taking part in a webinar. So there has been an increase. And this is also something that has been very good, because we have got to know new functions of these online tools. You can see them on these pictures. We are at the moment sharing a screen. We are recording the sessions, and we have the function to mute and unmute. And these are very helpful tools that we have got to know in this pandemic times. But if you put those new functions into the context of trade secrets, there is also a downside, because it has become even more easier to share information and to document this shared information on these online tools. So as the restrictions of the pandemic and the speed in which they came have surprised us all, the increased use of this technology mostly came without proper training for employees. So we have, on the one hand, an increased sharing mentality because it has become much more easier to do so with broad mailing lists, with online meetings where hundreds of people can participate without even leaving their desks. On the one hand, and on the other hand, we have still the need to protect our trade secrets and to protect and limit the access to them. So the consequences that come from this new situation is that sharing on online platforms can sometimes only lead to a funny story. You may all remember the cat lawyer who wasn't able to turn off his filter during his court hearing. This is just something that is funny, no harm, no foul. But sometimes the use of these technologies can lead to more sensible data that is unintentionally shared. For example, one of my colleagues, he attended a court hearing, a virtual court hearing a few weeks ago, and the judge shared his screen. And when he did that, there was a small information window popping up on the right bottom saying that he got an email about his new vaccination date. And that was probably an information that he didn't want to share with the participants of this court session. So now just imagine that a company has an online meeting with their longtime supplier, and during this session there is an email notice informing the participants that this company is also taking a new meeting with the competitor of their supplier. This is something that might lead to a detrimental effect in their business. That can happen due to this new meetings, just to name one example. So what I would like to do, and my goal with this presentation, is to raise awareness that these new online meetings have side effects. Even though recording is more comfortable than taking notes, if you consent to recording, the information is stored, and once stored, data cannot simply be returned. It remains on the system. Screenshots of shared screens can be taken, and unmuted internal discussions can be overheard. So there are risks in this use, especially if we're talking about trade secrets. Now that we have heard what trade secrets are and how the risk of disclosure is imminent, I want to point out some ways of how they are already protected under the law. There are international legal frameworks that also address trade secrets and trade secret protection. There is the TRIPS agreement. Article 39 provides some general standards and definitions of trade secrets. They are mostly aligned with those the WIPO has posted on their website, and I have informed you about in the beginning. There is also the Paris Convention, but that only gives a general perspective on how to protect and obliges its members to grant general protection against acts contrary to honest commercial practice, but it is not really a grounds to address trade secrets violation. There comes the national laws in play. Most national laws provide at least remedies in case of unlawful disclosure and breach of confidentiality, but still we have to be aware, and we are advising our clients to that the standards for trade secret protection vary from country to country, and the applicable jurisdiction in cross-border businesses is sometimes unclear, and the provisions in those laws is mostly reactive. So it is difficult to only rely on the protection that the already existing regulations offer. And therefore, there is a need to, or we have identified a need for companies to protect their trade secrets on their own and improve the existing law that they can rely on. And there are also two areas that we advise on. The one is the prevention, and the other one is the precaution. The prevention relates to technical measures to ensure security of your systems, data security, such as secure email communications, firewalls, and all that mostly is already in place and gives protection on external factors and cyber attacks. Administrative measures are also very important to limit the excess. Keep it to a need-to-know basis when you're handling trade secrets, and train your employees to inform them about the risks of digital sharing, and that not all useful functions are also without risks in that context. And the other part is the precaution, because sometimes it still happens that a trade secret is disclosed, and if you can't really rely on the legal framework that is provided under the law of the you're unsure what legal framework is applicable, it helps if you have created your own legal framework. And therefore, we always advise our clients to use non-disclosure agreements before any negotiations, cooperation, or any business exchange in general, and include passages for confidential information in other contracts as well. And coming to my last slide, I want to point out some general steps that can be taken on how we advise our clients to do that when they use, for example, NDAs. The benefit of such NDAs is that you can define the term of trade secrets in your own way. You can define it wider than the applicable law. For example, in Germany, we can do that by including all information that is exchanged during a business meeting, and not only limited to those that are commercially valuable. You can define the purpose of the exchange and therefore exclude other uses that may be allowed under the law, or exclude allowed methods of uncovering those trade secrets, for example, reverse engineering. And another part that is a big benefit of NDAs, you can include contractual penalties. So you have an additional deterrent for your partners to breach the confidentiality, and you have another remedy that you can rely upon. And the second area we advise on relates to this administrative measures. Establish internal guidelines. Who needs to know what kind of information? Make that clear from the beginning, so that you at the end don't have to find out where the information was shared or who shared it, and if he was allowed to it. Prepare guidelines on how to use digital tools. Raise awareness with your employees to show them the risks of those new tools that have seen an increase in use due to the pandemic, and implement those protocols early on. We have noticed that this is sometimes difficult for young companies, especially startup companies, because they have flat hierarchies, and there is a mentality of sharing in these companies. But the earlier you start implementing those guidelines or those measures, the better you are protected later on, and the easier it is to protect your trade secrets at a later date. And those are some of the ideas I want to leave you with, and I now hand over to Arpita for the Q&A session. Thank you.
Thank you, Patrick. Thank you, Jana, and thank you, Anita. It was a really helpful presentation thing, I think. So I would like to ask Marvel if we have any question answer from our panel.
Yes, we have a couple of questions come in. And sticking with Patrick, with those NDAs you were talking about, is there any clause you would recommend to include in NDAs given the increased digital sharing?
Thank you, Meryl. Yes, good question. I think what we have included in our practice in the last year very often is take care that data is also something that you have to account for. So if you are the disclosing party in an NDA, include an obligation for the recipient to use sufficient software tools for data deletion after the NDA or after the business relation ends, because sometimes you are not even aware that there is data saved somewhere because it is not physical, identifiable. It is not on a hard drive. It is somewhere in the system. And the counterpart for that is what we also advise our clients on is if you are the receiving party, make sure that you can fulfill such obligations. Because what we have experienced is that sometimes data is stored in disaster recovery full system backups, and to delete one specific information out of this full system backup can occur in astronomical costs and lead to astronomical costs. So make sure that if you receive such a clause, that you also know that you can fulfill this clause, but make sure that you cover data as a specific form of the representation of information, and that is something we would advise on.
Okay, our next question is for Dana. What should clients or brand owners take away from these new changes that you've described to the US trademark law?
Thanks, Meryl. I think they should take away is that, first of all, that trademark registrants, brand owners, should be prepared to prove that their mark is in use and should be prepared to be challenged. So, you know, in addition to it ensuring that that use is taking place, it also means keeping good records and consulting with U.S. counsel to understand exactly what may be required to be produced and what are considered acceptable specimens of use in the U.S. I think also it means that brand owners are being encouraged to more actively make challenges to third-party registrations in the U.S. So that's the other side of the coin, which is to consider using these new strategies as part of your enforcement portfolio, and to take advantage of the fact that these new procedures are meant to be easier, faster, and less expensive than those that are currently in place, and that brand holders should really consider taking advantage of them.
And do you think this will do what it's intended to do, i.e. clean up the register and reduce the number of registrations where there is either insufficient or fraudulent use?
I think it's definitely a step in the right direction, and the question is whether the new procedures will be regularly, frequently used. I'm anxious to try one of them on behalf of a client myself, and determine, you know, what is the cost of doing this, and how well does it work, and you know, are the registrants able to easily overcome a challenge to use, or is the office going to be quite strict in reviewing the evidence that's submitted? So I think that's still an open question, but I'm very optimistic that it will help.
Thank you. As we come up to the hour, one last question here for Patrick. You talked about recommending internal guidelines. Do you have any examples for internal guidelines? How can businesses implement such a setup?
Yes, Mara, thank you. Well, I think there is two different approaches to that topic when you talk about guidelines. There is a general approach. I already talked about employment clauses, so put in clauses in employment contracts already that bind your employees to confidentiality, and then simple work instructions, manuals explaining on how to use technology, how to use online tools, and regular training to keep the awareness high. It not necessarily needs to be a guideline on how to use it, but to raise the awareness that there is a risk involved that might also help for employees to ask the right questions at a certain point. So this is something that we would recommend. And then if you have very specific information that has a high level of protection or a high value for your company, in that cases, I would also recommend a specific approach where you have to identify the risks for this specific information, and then work from there on, and don't keep it general at that point. But that would be something to individually measures for this specific information.
Thank you. Over to you, Arpita.
Thank you, Mary. So thank you everyone for joining with us today. And this is our information. If you wish to contact any of us anytime, or Mackrell headquarters also, please feel free to reach out to us. And we will send you a thanks note for joining this information, joining this webinar, along with the video recording. If you wish to share this information with your client or any other colleague, please feel free to do so. And thank you once again.